I'll now call the first case, 115293 and 294, 295, and 305, State of Kansas versus Jacqueline Coleman. Counsel?
May it please the court, Caroline Zuschek of the Kansas Appellate Defender Office here on behalf of Mrs. Jacqueline Coleman. And if I may, I'd like to reserve 4 minutes for rebuttal.
4 minutes is reserved. Thank you.
Briefly, this case ended up here after Ms. Coleman was convicted of 4 counts of felony theft after a prior conviction, those crimes occurring in 4 separate years, and sentenced on 2 separate dates. And this is the direct appeal from sentencing in the final of those cases and the appeal from the revocation of her probation in 3 of those cases. And the sole issue before this court is whether the district court properly scored her criminal history as a C in each of those cases by classifying her 1992 involuntary manslaughter conviction as a person felony. And for the reasons I will outline, it erred by classifying it as such. This case is a bit like a game of pickup sticks. The law has changed significantly since the briefs were first filed, and indeed since she was first sentenced on these cases in 2014. And I think to get to the answer in this case, which ultimately resolves in Ms. Coleman's favor, we sort of have to unpack each stick one at a time. And so I'm going to start with what I think are the easiest sticks to reach, which is how you would play the game. And that is that her direct appeal from sentencing for 15 CR 2140 would be controlled by this court's decision in State versus Wettrick. After she committed the offenses, but before she was sentenced, the legislature amended 216810 to specify how to classify a pre-KSGA offense for criminal history purposes. And it stated that the classification should be made by comparing the offense at the time she committed it to a similar offense in the Kansas Code at the date of the current crime of conviction. And there was a legislative amendment to that effect, and it went into effect after she committed the offense, but before she was sentenced. And there was also a retroactivity clause. So, ignoring for the second that there could be ex post facto implications in some cases, there wouldn't be one in her case because it wouldn't disadvantage her to apply the amended statute. That statute uses the word comparable. In Wettrick, this court held that comparable, based on statutory interpretation, must be defined as an offense with identical or narrower elements. Because Wettrick came out while this case was pending on direct appeal, and even though Wettrick was looking at the word comparable in 216811 as opposed to 216810, it's an axiomatic, principle of statutory interpretation that if the legislature uses the same word within different parts of an act, it has the same meaning. So our contention is, of course, that Wettrick would apply to in-state priors and the definition of comparable in 216810 and would result in her most recent case, her criminal history being classified as an E because the elements of manslaughter in 1992 are broader in certain respects than the elements of manslaughter.
Would you say how they're broader?
Yes.
How are they broad? How is the 1992 statute broader? To me, it seems like it's more specific. But
in certain ways, it's more specific. Certainly, I mean, for example, the killing had to be unintentionally done. That was an element of proof that was required.
And even the distinction between wanton and reckless seems to be more specific.
It seems to be a higher degree of culpability than reckless. I would certainly agree with that.
All right.
So those aren't the ways that it is broader. There are 2 ways that is broader. The 1992 version prescribed killing another in the commission of an unlawful act not amounting to a felony. And the statute in 92 or 91, which is when she committed it, but it was the same statute since 82, defined unlawful act as a violation of a misdemeanor or an ordinance enacted for the protection of human life or safety. However, in the 2011 version, which remained the same throughout all of her cases, the offense must have been committed during the commission of a misdemeanor or a felony. So an ordinance violation wouldn't apply. So she could have committed manslaughter in 92 during the violation of an ordinance, but that would not be a manslaughter conviction now.
But you'd still have to have the wanton element, and it seems like that is adverse to your position. It's not just the fact that you could get nailed on the ordinance. You'd also have to be able to show that your disregard of the ordinance was somehow wanton and not and in disregard of someone's life, right? You've got the wanton requirement
Certainly.
also with the ordinance, so it's not just that.
But that is the element that is broader. So the reckless element is certainly narrower in the present offense, or certainly narrower in the prior offense. But the element that is different is she could have committed manslaughter by violating an ordinance then.
Your point is that comparable has to be comparable.
Comparable has to be identical or narrower. And this is
On
not
all
identical
elements,
for
not
all
just
elements.
the
Not
culpable mental state.
right, not just the mens rea or the actus reus, but
you
all
think-
elements.
Do you know of any ordinance that's implemented for the protection of human life that criminalizes behavior that's not also a misdemeanor or felony?
Smoking in a public place.
You think that that would qualify under the 1992 version of the statute?
Sure, why not? I can't think of a reason why it wouldn't. And I can imagine others. While it certainly may be a very narrow class of ordinances, again, which ordinance was at issue is a factual finding. What's relevant is, are the elements themselves narrow or identical? And in this case, that particular element is not.
I'm just
narrower.
saying it's not necessarily obvious to me that the fact that it's an ordinance makes it narrower.
Well, an ordinance
Or
can,
excuse me, I misspoke, makes it broader.
but there are many ordinances that are enacted for public safety purposes that aren't necessarily misdemeanors.
But that's,
Like
we're sort of
no running at a
speculating about
swimming
that.
pool, no smoking in a public place, no diving in a shallow end, no swimming in a state lake, no boating. I mean, certain things that would be for the safety of individuals.
But don't we have to reach a legal finding that a violation of those kinds of ordinances would qualify a defendant for a conviction under the 1992 statute? And that also doesn't seem obvious to me.
But under the 1992 statute, any ordinance violation where the ordinance was enacted for public safety would be an involuntary manslaughter conviction. Those
But
are
only if it was done in a wanton manner.
right.
And so, if you do any act in a wanton manner, I mean, I can't imagine how there would be a link to smoking in a public place or running in a swimming pool.
How about diving
Or
into
diving.
a shallow end? If you push someone.
That's what I was
In
thinking. Like you
1992,
dive into
push-
a pool
If you
and
push someone in, and
Right.
it head first into a pool.
But that would be an assault as well, or even a battery. I mean, that's just hard. I mean, you know, it's difficult to imagine that situation.
but again, we're getting into the facts and not the elements.
And so that's where DeCamp stops us.
Right.
That's your position?
Yeah, that's my position. And that's not the only element that is broader. There's a second element that is broader. And that's that in 1992, the statute forbade killing during a wanton commission of a lawful act. So I guess like you're legally allowed to go boating on Geary State Lake, but if you do it while intoxicated and you run over some recreational swimmers, that would be wantonly doing something that's legal, boating. But in 2011, involuntary manslaughter, in order for it to be classified as an involuntary manslaughter, the act must occur during the commission of a lawful act in an unlawful manner. So I guess my speedboat analogy would be better there. But yeah, so in 92, wanton commission of a lawful act, and present unlawful commission of a lawful act. So those are different elements. Because those elements are broader in 92, those specific elements, there are other elements certainly that are narrower, but all elements must be the same under DACOM and under Wettrick, as this court held, then she would receive the benefit of Wettrick in this case. What's more complicated is whether or how we determine what the proper criminal history score would be in her 3 prior cases. These cases were committed in 2012, 2013, and 2014, and sentenced on August 15 of 2014. Now, Murdoch 2 tells us that we determine the legality of the sentence at the time the sentence was imposed. So what was the proper criminal history score in August of 2014? And I think there are 3 ways this court can answer the question, and I'm going to start with what I think the 2 least likely options are and end with what I think the most likely option is, because I think it'll generate the most discussion. So there are 3 ways to determine how we classified in-state pre-93 prior convictions, pre-Keel and pre-the legislative amendments, and post-Murdoch. And the first answer is that she would get the benefit of the rule announced in her direct appeal, which would be Wettrick, on her PVs under Dickey 2. In Dickey 2, this court applied the rule of Dickey 1 to Mr. Dickey's cases that were probation violations. That same could be done here. We could apply the rule that would apply in her direct appeal, which is Wettrick, to her PVs. This is slightly problematic, of course, because Wettrick wasn't the law at the time of her priors, and in fact is based on a statute that didn't exist at the time of sentencing of her priors. Nonetheless, this court could find that a PV appeal is more like a direct appeal than like a collateral attack on a sentence, because a collateral attack on a sentence happens after the sentence is final, whereas a direct appeal happens when the sentence is still subject to modification by this court. And a PV is more like a direct appeal than like a collateral attack, because the sentence doesn't become final until it's imposed at the dispositional hearing. Because it's always subject to modification under McGill, we would argue that a PV is more like a direct than a collateral. And so therefore she would again receive the benefit of Wettrick, since her sentence wasn't actually imposed until the dispositional hearing of her probation. If this court doesn't like that, or doesn't view PVs as more like direct appeals than like collateral appeals, there's a second way that Ms. Coleman's criminal history can be scored, and that's by applying Murdoch, which was the law at the time that she was sentenced. Now, there's some pitfalls with this approach as well. Nonetheless, I think there's a compelling argument. So in August 2014, Murdoch was the controlling law, and it had not yet been amended. So the version of Murdoch that was the law at the time of her sentencing was the version of Murdoch that read, that had the quote, "We recognize the result of this decision would be that all pre-1993 offenses would be classified as non-person felonies." A result the state finds absurd or disagrees with. Subsequent to that decision, she was sentenced. After she was sentenced, this court held the modification hearings in Murdoch and changed the language to say only out-of-state pre-1993 convictions should be scored as non-person felonies. But at the time of her sentencing, there was no published case saying that Murdoch did not apply to her. And in fact, the language of Murdoch is broad enough to have applied to her. Basically, in Murdoch, this court found that you gauge an out-of-state offense by comparing it to the offense, a pre-1993 out-of-state offense, by comparing it to the offense in Kansas that existed at the time the out-of-state offense was convicted. And even though this court found that 216810 D6, I think it was 4710 then, which referred to unclassified felonies and stated they should only be referred to as misdemeanors, probably was only intended to apply to very narrow subset of crimes, which were crimes enacted after 1993 and not given a classification. It nonetheless applied D6 to uphold Williams and said, even though we think that this was probably narrower under D6, we're going to hold that the out-of-state offenses should be classified as non-person crimes because they were not classified. So that was the holding in Murdoch. And subsequent decisions that said that Murdoch didn't apply to in-state crimes said, well, the analysis in Murdoch started with 6811. And in fact, it did, but it ultimately rested on the definition in 6810, which applies equally to in-state as well as out-of-state offenses. So the second way that this court can give Ms. Coleman the benefit of the criminal history score that she's entitled to would be to apply Wettrick, or would be to apply Murdoch 1. The final, and probably what I think the most likely path is to look at what the law was in the narrow time period in which she was sentenced. And if the court were to do that, it would ultimately probably perform the same analysis that it did in Keel. In 2014, there was a legislative silence as to how to classify pre-1993 in-state priors. The legislature did not tell us how to do that. In Keel, this court decided that what the legislature intended was for all crimes to be scored, and for person crimes and certain crimes with higher severity levels to have a greater impact on a person's criminal history score. And in doing so, this court filled in the legislative gap in sentencing, in the KSGA. Now, had the court addressed the issue prior to Keel, we can conclude retrospectively that that's what it also would have done. So even though Keel came out after she was sentenced, we can assume that had the court taken up the question then, which it didn't, because by the time those cases made it up on appeal, Keel had already overruled Murdoch. So we never had to answer how pre-93 convictions in state would be scored between Keel and Murdoch. But now we have to answer that question because Murdoch 2 says the time that you were sentenced is the relevant time. But we can assume that this court would have come to the same conclusion it did in Keel had it addressed the question at that time. However, then we're left with, and that the Keel opinion, of course, decided the same thing that the legislative amendment did, which is that we look at the comparable offense at the time of the present crime of conviction. So then we're left again with, well, what does comparable mean? And Wettrick, unfortunately, doesn't answer this question because Wettrick was based on statutory interpretation. And now we're talking about a time pre-statute. There is no statute in 2014 that told us how to classify. The comparability is just the test that this court imposed on that. So you can't just say, well, Wettrick would say that comparable means identical or narrower. This court instead would have to address the constitutional question. And the constitutional question is, what does Descamps, Apprendi, and Mathis require in terms of the definition of comparable? And we think that that answer is clear. It requires any sentence-enhancing conviction have identical or narrower elements. Otherwise, the court goes beyond its role in identifying a prior conviction and is forced to make implied findings of fact that she didn't violate an ordinance when she was convicted of the misdemeanor, that she didn't commit a lawful act in a wanton manner. Now, the statute is potentially divisible in that case, and this court could remand it back to the district court to see which elements that she was convicted under. But it would nonetheless require answering the constitutional question.
Counsel, you're well out of time. Are there any other questions?
My apologies, thank you.
Oh, there you go.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I'm going to take, I think, a somewhat different approach here to this argument, and I'm going to start with some statements that I think everybody can agree with. I don't think any of these points that I'm going to start with are controversial at all. First off, we can all agree that the sentencing guidelines were adopted primarily with the goal of promoting consistency and fairness in sentencing. Second of all, as part of the sentencing grid that was adopted, you have the axis that takes into account an offender's criminal history. And the legislator made a very conscious decision to treat crimes committed against persons more seriously. Obviously, if you look at that axis, you'll see that somebody can commit an endless number of non-person offenses and yet still not end up in the most severe criminal history categories as long as they don't also have person offenses on their record. And I think we can all agree that the reason for that is logical. The degree of harm that comes with a property crime, while serious, is not as severe as something committed against a person. Whether they suffer actual physical violence or the threat of violence or simply the psychological harm that comes with being a victim of a crime. I'd also note that I think we'd all agree that the case law tells us that when you're looking and trying to apply the sentencing guidelines, you apply the guidelines as a whole. You look at it in its totality. Another non-controversial, well-settled point of law is that the courts are to interpret statutes in a way to avoid absurd or unreasonable results. Now, with all of those general points of law, factually, what we're looking at in this case is that the prior conviction that we're here to discuss is an involuntary manslaughter. To put it bluntly, this defendant killed a person back in 1991. So we're here to decide whether killing somebody should count as a person offense. And I think that my argument is that when you look at page 9 of the defendant's petition for review, we have the defendant flat out stating in her petition that, quote, whether the crime was against a person is legally irrelevant, unquote, in deciding whether something should be categorized as a person felony. The state's position is that accepting the defendant's argument in that regard leads to the most absurd result possible, that killing somebody could be deemed a non-person offense. And so, as you might imagine by my comments to this point, while this case involves pre-93 Kansas offense, our position is that we would ask this court respectfully to reconsider the Wettrich decision, which is essentially the basis of the defendant's argument, at least with respect to the 2015 case that we're here to talk about. Our position is that Wettrich, in interpreting and defining the word comparable to mean identical, has in fact led to absurd results, where a crime that is the killing of a human being could be categorized as a non-person offense. Our position is that the case law for the years and decades before Wettrich, in which comparable was defined to mean similar but not identical, is in fact the correct interpretation and definition of that word. And I think that this case again illustrates that not only would we have absurd results, but we would not have consistency and fairness in sentencing, because and now this would be going towards more out-of-state crimes, but you'd have a situation where one person could kill somebody, have a prior in another state, and do the exact same thing that they could in yet another state, and one person would be categorized as a non-person, and in another it would be a person, simply because of slight discrepancies in the wording of the two statutes.
Counsel, let me...
Go ahead.
Thank you. I'll interrupt you there and ask, what this court, I think, at least in part, was wrestling with in Wettrich was the notion, the reality, that if we don't apply an identical or narrower test, the prior statute may in fact criminalize behavior that's not even a crime under the present statutory scheme. So that goes to the questions I asked your opposing counsel. I understand the sort of common sense argument you're making. Can you Is it possible for you to refashion that argument and answer the question whether or not the pre-93 law, in this case, would have ever criminalized behavior that's not a crime under the current scheme when the defendant committed the crime? Does that question make sense?
Right, it does. And I think my answer would be, like you indicated in questioning opposing counsel, I have a hard time thinking of any scenario where something would have been a crime under that, but would not be a crime today. Counsel gave some examples, and I think that Your Honors pointed out that perhaps the trouble with some of the examples she gave would be, would any of those examples include the wanton element? And if not, then we wouldn't be looking at a situation where something that occurred in 1991 would not fit under the current or the 2014-2015 version of the statute that was in effect at the time that these current crimes were committed. I just struggle, and I do think that also, as Your Honor pointed out, those are legal questions, I would say, more so than factual determinations. And so for counsel to argue that it would be inappropriate for the court to make any findings with respect to that issue because that would in turn violate the scams, I think that also is inaccurate. I think that would be more of a legal determination, as you indicated, as far as whether the elements of a certain ordinance from 1991 would then qualify somebody for an involuntary manslaughter conviction. But, one of the she gave numerous examples, but I just didn't see any that I think would actually fit under that. Even the example of boating while under the influence, she categorized that as a lawful act in an unlawful manner. Boating under the influence is not a lawful act, just like driving under the influence is not a lawful act. So I don't think that would qualify. And I think Your Honors pointed out some of the issues with the example of smoking in a public place and whether that would possibly qualify under the wanton element. And my answer would be no, I don't think it is. And so certainly even if this court were to...
Is your answer it is the pre-1993 statute is narrower, or do we ignore that analysis and just go to it's similar? And therefore it fits within the purpose of the KSGA.
I think both. Obviously, my preference, the state's preference, would be if you were to agree with my simpler analysis, if you will, to say that this court should revisit Wetridge and decide that comparable does not mean identical or narrower to, and under the old test where it simply means similar.
What do we do with the camps and the U.S. Supreme Court guidance on that question then?
Well, I think that with respect to that, our position is simply that states have the right to determine for criminal history purposes how something is going to be scored, whether it's going to be treated as a person or non-person. I think that's really our baseline position, is that's an issue of state law, and that states do have the discretion in determining from a legal standpoint how to categorize crimes from a criminal history standpoint. Obviously, this court, as counsel noted correctly, this court has to this point not decided the constitutional issue because it has determined that the issue could be resolved on state statutory interpretation. I would note, of course, that if this court decides that it does have to get to the constitutional question in order to resolve a case like this, obviously from the state's perspective, I guess the one advantage of that, not necessarily in this particular case, but in other cases going forward, would be that it would at least cut off some of these arguments from defendants when they're raised through a motion to correct an illegal sentence, because that statute does not include constitutional arguments. So from the state's perspective, I guess that would still be better than what we currently are faced with, which is that these issues can be raised at any time under a motion to correct an illegal sentence. But again, our underlying position would be that, yes, this court should simply go back to the prior interpretation and definition of comparable, and not reach the level where if a defendant can point to any minuscule difference that arguably made the prior statute broader, And again, that's just going off of legislative intent. The legislature wanted to treat person crimes more severely for criminal history purposes. And so when we have a defendant that's acknowledging that the crime that she committed was against a person, and here it's killing somebody. In other cases we've seen it's somebody that's arguing that a rape, sodomy, assault, crimes that clearly involve human victims are non-person. And so I do think that there is a way to, I think that the prior interpretation and definition of comparable strikes the correct balance there. It still takes into account whether something is similar, and if a prior offense was actually not committed against a person, then even under that test, a defendant clearly would prevail because it would not be similar to the Candace crime defining an offense as a person crime. So I think that the prior case law works. It should be readopted, if you will, that this court should revisit Wettrich. And again, Wettrich is really the primary basis that the defendant is using to argue in this case. She's entitled to relief by saying, well, if comparable means identical in the context of out-of-state priors, then it has to mean the same thing in the context of in-state. And on that point, I guess I agree that if you have two statutes both dealing with criminal history and they both use the same word, I think it's logical probably to interpret it the same way. It's just that our position is that interpretation should be that the crimes need to be similar but not identical.
Counsel, let's. I think I understand your position about what the test ought to be.
Sure.
Let's assume the test is Wettrich, because the statutes are so similar and so in-state, out-state. Apply that identical or narrower test to the specific arguments that are being made about why we should consider this involuntary manslaughter as a non-person crime. Do you agree that there's enough difference in the elements and that the old statute was broader, or do you think it was identical or narrower?
I do think it was identical or narrower. I think, again, as this court pointed out in questioning counsel, I think that wanton element is something that I think it's hard for the defendant to get past that. And that's why I think that some of the examples that she gave today or in her petition and brief, such as the smoking in a public place, I don't see how smoking in a public place would qualify as wanton conduct. And so I think that even when you look at I know there's just the one subsection, but I guess the second portion of that subsection of the prior, of the 1991 statute, I think that even if you're dividing it out that way, that particular portion of it is not broader. It is, in fact, identical or narrower because it includes that wanton conduct, which is this court has indicated. That's a more narrow, stricter element than is present in the current statute. And so I've yet to hear an example from counsel that I think would qualify that prior statute as broader. And to the extent that they could come up with any, I do think, again, that would be a legal question more so than a factual question. And I think
is the right question to ask whether or not, as a matter of law, it's possible to violate the earlier statute without violating the later statute? Is that the appropriate question to ask?
I think that's certainly one question to ask.
Wouldn't that answer the question of whether or not it's broader?
Sure, yeah. If you answer that question and say it's not possible, then clearly the state would win in that position. If it's not possible, the state would prevail.
But the opposite would be also true, that if the answer were yes, then the state would lose because it would be broader, right?
Except this issue I struggle with in that regard would then be, would it really be I think that there could be, perhaps under the modified categorical approach, then you could remand it to at least determine whether the charging documents or anything in the previous case would tell us whether she was in fact convicted in that case of violating an ordinance. It might be possible to tell just from the documents that the SCAMS allows whether in fact she was, and so in that situation we could remand and we could say, well, okay, even if in a theoretical case somebody was convicted of violating an ordinance, here that's not what we have. If we can determine that in fact what she did in 1991 was a violation of a felony statute or a misdemeanor, then we wouldn't have an issue in this case. So I think while the question Your Honor points is certainly still an important one, if that question is answered contrary to the state's position, there would still be an avenue to remand the case and determine whether she was charged with violating an ordinance or not. I think I've made all the points that I intended to make today.
Can I ask one real quick procedural question?
Of course.
From the state's perspective, where are we procedurally in this case with respect to the different convictions?
Right.
And real specifically, I just want to know whether you think we're on direct appeal or not.
And that's a fascinating, that's something that we've thought about over the years, not only in this context, but in others, because it does seem to be kind of this gap in between when you're talking about probation violations, because it's not a direct appeal in the way that I would generally think about. You go to trial, you get convicted, you're sentenced, and within 10 days you file a notice of appeal and you're challenging your convictions or your underlying sentence. I also understand counsel's point that this is not something where there's a collateral motion that she's filed and is seeking to appeal, but I guess my position would be that this is not really a direct appeal when you don't challenge your conviction or sentence. I think I would prefer this court to construe direct appeal to mean just that narrow circumstance.
Let me ask a quick follow-up question. Is the defendant, in the state's view, currently serving, set aside the 2015 conviction and sentence, is the defendant currently serving the original sentence or a new sentence that was imposed after probation revocation?
Well, I think factually in this case, I think she is serving the original sentence because, unless I'm mistaken on the facts, I don't think the court at the revocation hearing modified the sentence in any way. I know obviously the court has the discretion to do so, and I think in a case where if the court were to do that, maybe there could be an argument made that they were certain that she's serving a new sentence and therefore you could consider it maybe a direct appeal. But again, my recollection is that here the court simply revoked and imposed the underlying sentence. And so since nothing changed, our argument would be that in these particular facts, it is just the original sentence that she's serving.
Other questions? Thank you, counsel.
Thank you.
May it please the court. Mr. Maloney's argument that a person crime should be a crime committed against a person is seductive and it is easy to apply. The problem is the legislature didn't say a person felony is a crime against a person. So respectfully, we would argue that should that be the way that we determine a person non-person felony designation, that redress needs to lie with the legislature. And quite frankly, it has. The most recent codification in 2019 of how to determine whether a pre-93 or an out-of-state conviction as a person felony is to look at was a person harmed and a number of other criteria. But frankly, while it would be easy to apply, it's not what the legislature did. There are a number of crimes without a person victim that are called person felonies. For example, any KORA violations, for failing to register as a sex offender or a violent offender. While there may have been a person victim in the underlying case, there's certainly not one in failing to register. So furthermore, even if this court wanted to go that way and found that the redress could be here instead of with the legislature, the Constitution requires a different result. I know in Keel and in the Court of Appeals case, State versus Wagner, they looked at was a person physically or emotionally harmed or could they have been by the crime? But that's a factual finding. For example, robbery requires the taking of property in the presence of another person by threat or force of threat. none of those elements require a finding that the person was physically or emotionally harmed. Certainly, we can factually determine that that's likely, but that's not an element that was ever required to be proved to a jury. In Mathis, the court explained why that's a problem. Those non-essential facts are not elements of the crime, and therefore they're in the records. They may be subject to mistake simply because the jury isn't required to find them. And moreover, a defendant has a jury trial right to have any sentence-enhancing facts proven to a jury beyond a reasonable doubt. So the Constitution does not permit the person is a victim approach that the state proposes. And switching tracks for a little bit to get at Justice Stiegel's question, how can someone commit a violation of the prior crime that would not be a crime presently, and does the wanton element catch up? We would argue no, the wanton element is the mens rea element, and we're talking about the actus rea element. But assuming that it does get hung up, say that I walk in here and there's a giant sign right in front of me in 1991 that says no smoking. And right next to that sign is a person with an oxygen tank. And I light up a cigarette, and as I'm lighting up the cigarette, I'm violating an ordinance by lighting up the cigarette in public, and the spark goes off and ignites the oxygen tank, and that person dies. I'm wantonly disregarding the sign in front of me. I'm wantonly violating the ordinance, and I've just killed someone in doing so. So there is an example of how the crime can be committed. Is it likely that that's the crime that my client committed? No. But the question isn't, did my client commit that single version of a crime, which is prohibited? The question is, are the elements of the prior crime in any way broader than the elements of the present crime? And in this case, they are. And if this court has no further questions.
Real quick, do you agree with the state that your client is currently serving the sentence that was original, that the sentence your client's currently serving on the 2012 to 2014 crimes is the original sentence?
That's a trickier question to answer, and I would have to get back to this court. I can't remember if it was modified or not, but even assuming that it wasn't, it could have been modified, and I guess that's the distinction we'd ask this court to note if this court wanted to apply.
So your argument would be that at the probation revocation, your client, a new sentence was imposed on your client, and you are now on direct appeal of that new sentence.
Yes, because a new sentence could have been imposed. However, you don't need to find that to find for my client, because if you answer the constitutional question, the change in the law occurred in 2000, so her sentences were illegal when they were imposed in 2014.
Other questions? Okay, thank you, counsel.
Thank you so much for your time.